That brings us to our third case, which is 127838, Paxon versus the Estate of Hunter Lane. The parties could announce their appearances, please.
Yes, Charles Cooper and Will Dowster were here on behalf of the appellant, the Estate of Hunter Lane.
And will you both be arguing, Mr. Cooper, or splitting your time arguing?
No, I will be arguing.
Okay.
Dakota Persinger on behalf of appellee Darlene Paxon.
You may proceed whenever you're ready, counsel.
I would like to reserve 3 minutes.
3 minutes is granted.
Good morning, may it please the court. Yeah, I've read the court's notice regarding preservation, and I will spend some time on that in a moment. But first I want to say one thing about the underlying issue at the top, and our position that it is prejudicial to introduce THC evidence without expert testimony. That position is overwhelmingly supported by the case law before the court today. It is supported by, in fact, it's unchallenged. The cases that we cite to from Kansas that show that Kansas courts recognize that there is a taint, there is a stain, a prejudice that comes when you label a party as a drug user, or specifically in some of those cases as a user of THC, of marijuana. You see it. You see also in the Kansas cases, for example, the Kent case, where the Kansas Court of Appeals recognized that there is a difference between mere presence of THC in somebody's system and actual intoxication.
You need context.
Or causation, right. And then you have those 8 cases from other jurisdictions which are in sync with what Kansas said in those instances, and all hold that you need something more. You need expert testimony, to sort of link it up, because a lay person is not going to understand when you just throw out a number without any context. Even the one case that the appellee is relying on, the estate of Bush from Michigan, which is a little bit lax compared to the other 8 cases that we cite. But still, even in that case, they had experts on both sides. And those experts were able to talk about what the brain chemistry was, what would happen in the brain chemistry that could affect and how it would affect a person on THC. So even in that case, you had experts. So we are asking for this case to be remanded for a new trial. But as for the preservation issue, first thing I want to say is that the preservation rule is prudential, not jurisdictional. You see that in Showalter at 345, for example, and you see that in a lot of Kansas Supreme Court cases. And as the Court of Appeals observed in—
But is it prudential with an evidentiary issue? Aren't we constrained by the statute?
Well, the statute—
and the admission of evidence?
I'm sorry, yeah, I believe you're referring to the preservation statute
Yes.
from 1960, that was enacted in 1963 and took effect in 1964 on January 1st. And that has been, interpreted by the Supreme Court in a lot of cases. You have that big case, King, State versus King, in 2009, I believe. And then you have some very compelling dissents from Judge Johnson in, for example, State versus Inkelar and State versus Holman, where he says, it's in the context of a motion in limine, it really isn't there that wouldn't be a timely issue. But, it was the dissent. And what you see in the cases since then is that a more of a middle ground position is is looked at. And as the appellate court in Great American Insurance versus Wall, and that's at 404 P3D 697, it's an unpublished decision, the 2017. The Kansas appellate courts have on occasion refused to strictly apply the contemporaneous objection rule in some contexts upon finding that the underlying purpose for the rule has been satisfied.
And normally, don't we have, in those situations, a continuing objection, or maybe we've got a bench trial on stipulated facts, and so everybody knows how the evidence is gonna come in. But the whole purpose behind this statute is that, hey, before trial, we all think we know what's gonna happen, and we're gonna have an agreement on what should or shouldn't come in. But then you get to trial, and people open the door, evidence comes in differently. Maybe you decide you want the report in, and you think the jury might be receptive to the information, and so you change your mind. And so you let the evidence come in, and so nobody knows that you still have an objection because you've sat there and let this evidence in.
Yeah, first of all, if an objection had been made when the evidence was actually played to the jury, or in the case of the report shown to the jury, then this would be a non-issue, a no-brainer. But what this court is saying is that you look at whether, you talk about, I think it's Spagnola, State versus Spagnola, which is 295 Can 1098, 2012 case, where they say, look at the stated that the contemporaneous rule is relaxed to fit a particular trial situation. And in that case, it was looking at a bench trial. But as for, the Great American Insurance case, what they're saying is you look to see if the underlying rule has been satisfied. And they're citing to Hart and to State versus Hart, State versus Spagnola, and State versus Breedlove. And that begs the question,
So then how
what
did
is the purpose of the rule?
Right, how did you satisfy the
Right.
underlying purpose?
Exactly. What is the purpose of the rule is stated very, very well, I think, in State versus Showalter, where the court says, the purpose of the rule is self-evident. A timely and specific objection allows the district court to consider as fully as possible in context whether the evidence should be admitted, which reduces the chance of using tainted evidence. And then looking at Spagnola and the focus on the trial situation in this case is a videotaped trial deposition. And the other cases that I saw, certainly the Supreme Court cases, I found no cases that were dealing with a videotaped trial deposition.
How does that make a difference? I guess I'm confused.
Exactly. What happens, if you look at volume 10 that we cite to, pages 53 and 54, you can see the judge is saying, okay, this is in, this is out. This is in, the objections we're cutting out. Here's how the judge put it on page 2 of volume 10 at the beginning of the hearing. We are meeting in the court's library for the purpose of reviewing some objections to 2 video depositions that are intended to be used in the trial as testimonial depositions, and to try to make those viewings for the jury smoother, we are addressing in advance objections that were made during the deposition on which counsel have not been able to agree, or extractions or questions and answers to be included and will show to the jury.
Right, but my question is, how does the judge have an opportunity to have the context for the admission of evidence, which is the trial, how things have come in at trial? You're only talking about what happened before the trial and going through, but what did you do at trial to resolve the issue of whether or not the context of how the evidence came in impacted that decision that was made before trial?
Are you saying that the deposition was somehow redacted in some way?
Yeah, well, what the court is saying is that this part comes in, this part doesn't. So that is a redaction in a way, yes. But what was happening is the judge doesn't want to have to, in the middle of trial, say, okay, jury, you're going to wait. We're going to go and find a videographer. We're going to cut the testimony. He's cutting the testimony now. And everything that came in on marijuana, as you can see in the briefing and in the testimony, and in the record before the court, everything that came in that hearing. It was only the the counsel for the appellee actually, makes the point that there was this one time when this one piece of evidence is coming in. It's not, this great percentage of the trial. And when that happened, the judge is cutting it and putting it into a can because he doesn't want to have to take a break in the middle of trial. And so no other evidence came in, and the judge ruled on the exact testimony and report as it was at trial later on when he made his ruling. And he had put it in the can to push play later.
No,
But isn't that,
go ahead.
but isn't that true of, that's true of any in limine hearing held before, right? You're describing a process that occurs for virtually every trial. So what then is the purpose of the contemporaneous objection at trial? If you're describing what happens 90% of the time, then you're essentially saying there's no reason for the contemporaneous objection rule.
No, not at all. I'm saying that you look at the particular circumstances, and in this case, there's no other evidence on this issue, and it's been put in the can and it's been placed before the jury. And that's only one way the rule is satisfied. Another way the rule is satisfied is that there was a standing objection. You talked about a continuing objection. In State versus Browning, for example, they say a continuing objection is lodged. A failure to object when the evidence is subsequently readmitted does not bar raising it on the issue on appeal. And what happened here, as you see on volume 10, page 42, line 9, is I have agreed to a continuing objection. That is trial counsel for the estate of Hunter Lane saying that in the hearing, and he's referring, as everybody's looking at the testimony, he's referring to the fact that there was a continuing objection. He didn't even offer it. He accepted it from opposing counsel, and I'm running out of time. But that's the second way. There's a third way, and the third way is that was contemporary because it was made at the time that the objection happened.
Did you say the objection was by opposing counsel?
There was an offer to make to have a continuing objection that was offered by opposing counsel and accepted by Mr. Powell, who was trial counsel for Hunter Lane.
And that was page 42, volume 10, is that what you said?
And that was in the.
Yes, Your Honor.
In the limine hearing, correct? Pretrial hearing.
Yes, Your Honor.
Right.
They're referring to the fact that there is a continuing objection. And any more questions right now, or I'll come back and deal with it.
Good morning.
Good morning.
First, I'd like to address the preservation issue. Counsel for appellant was right. He said if no objection was made, it's a no-brainer. Well, there wasn't a continuing objection throughout trial. The continuing objection that they talk about at the end of their argument, they mischaracterize. It was a continuing objection limited to the deposition of the detective. It was not a continuing objection throughout trial. If you look at the portions of where the court is discussing this deposition, part of it is the estate's trial attorney saying, I've already said this objection 3 times. Will you just give me a continuing objection? Yes. So you don't have to continue to say objection to every question that I ask.
And that's to Detective Kemp's testimony, but isn't that where the report came in? The report came in through the detective's testimony, correct?
Correct.
Okay.
Correct. And so at trial, all the objections were resolved in this pretrial hearing with the court in the judge's library. At trial, there were no objections. In fact, there was a waiver of the objection because in opening, the state's attorney stood up and started talking about THC. It wasn't just the appellee's trial counsel saying this, it was also the defense's attorney saying it at the time as well. There could have been a host of opportunities to object or say something.
So you're saying because in opening they're drawing the sting, I mean, they know this is coming in, the decision's been made, and so they have to make a strategic choice to try to draw the sting of the evidence. So just because they talk about it in opening, you're saying that they couldn't still object to the evidence later when it came in, they couldn't still have their objection?
I wouldn't say that that one mention of it is purely dispositive of them waiving their objection, but if you look at the context of the trial, they surely aren't making it an issue during each of the 5 days of trial.
What do you mean? I mean, how are they supposed to make it an issue? I mean, that might highlight it for the jury if they're making an issue of it.
For example, for the admission of the report, we were outside of the jury's presence, and plaintiff offered Exhibit 12, which was the autopsy report, in its entirety. There was no objection lodged. There was no mention of reaffirming their objection, asking the court to reconsider, or anything along those lines. In fact, what they tried to convince the judge to do was materially alter the report. They wanted to redact out one sentence or one portion of the autopsy report to make the results inaccurate, incorrect. And so if we're looking for in Kansas to provide juries with the truth and accurate data to allow them to do their jobs and evaluate the evidence and do what they need to do, what they were proposing is the complete opposite of that. They're saying remove information and let other toxicology information remain in to where it
Which
looks
would
like
create
this.
a misleading result, like keep the beneficial information in, take out the negative stuff, and so then we have a misleading result.
Yes. And so all in all, I believe in the trial transcript, there was an absurd amount of words that were said. And the word marijuana came up 3 times. The word THC came up once. Defense counsel, trial attorney said marijuana once. We said it twice. And then we said THC once. Or I'm sorry, we didn't say THC. Our contention said THC. And so looking at everything in context, it doesn't make a big deal. It wasn't a central part of our case. It wasn't even iota of our case. It was just a blurb on the map that is now trying to be magnified.
So you're essentially arguing, okay, that even if this was an error, it was harmless, is what you're telling us. But I want to go back to opposing counsel's argument that the underlying purpose of the contemporaneous objection rule was satisfied here. And how do you respond to that?
It absolutely was not. The purpose of the contemporaneous objection rule is to allow a judge to remedy something that they've done erroneous in the past. That opportunity was never given to Judge Comer. They made their objection, we discussed it once, and it never came up again. They could have asked for a conference with the court before the testimony of Detective Kempf was played. They could have moved for a directed verdict on that issue. They could have done a host of things, but they sat on their hands. They didn't do anything. And now they want to make it an appealable issue to ask the court to remand it back to the district court for a retrial. Does that answer your question? Substantively, looking at the Reed test that both sides have cited, I struggle to figure out what step we are looking at. Looking at their brief in whole, it appears that they are primarily focusing on on the probative versus prejudicial analysis. KSA 6044-5. All of the cases that they cite, they do that analysis in the appellate courts. There's not one mention or objection at the trial level or in their brief to relevance. So step one is out. Step two, other rules of evidence or other legal principles, they don't cite any statutes regarding rules of evidence. So that's out. Other legal principles, they mask their attempt to, they try to slide in this attempt to say, expert testimony is required. Well, if you look at the context of the arguments that were made at the trial level, all of those arguments purely are prejudice versus probative. That is the core of each discussion that has been made on this topic. And so that's the correct posture to put this issue in. And whenever we do that, we know that it's an abuse of discretion analysis. And I feel like I hit this well enough in my brief, but the appellant holds the burden to establish any abuse of discretion. There is not one word in their brief, in their initial brief, saying that the court abused their discretion. They say the court acted contrary to the majority view. Well, that implies that there's a minority view. That implies that reasonable minds can differ. Now, I don't know if there actually is a majority or a minority, or if it's split down the middle. Appellant didn't cite enough cases for us to be able to truly tell the difference. But if we look at the Staten case from the Supreme Court, the standard for abuse of discretion says, quote, judicial discretion is only abused where no reasonable person would take the view adopted by the trial court, end quote. And then it goes on to say, if reasonable persons could differ as to the propriety of the action taken by the trial court, then it cannot be said that the court abused its discretion. The Estate of Bush case directly goes to show that there are different ways that this matter can be handled. One thing that's interesting about the Estate of Bush case that makes it analogous to this case is there wasn't an expert that was opining to impairment, similar to this case. But in that case, the court said it unequivocally is relevant. It gets to come into court. It gets to be considered by the jury.
But isn't that the only reason you would even draw attention to the THC in Mr. Lane's system, is for evidence of impairment? And then if, as follows that, that's the only reason to draw attention to it. But then if there's no connection, if there is no expert testimony and then no connection between the evidence of THC and impairment, then aren't we asking the jury to speculate?
I would say no, Judge. What the law says is KSA 6407 says all relevant evidence is admissible unless prohibited by statute. There's not an objection to relevance here. There's no statute that's cited to exclude it. In their reply brief, the appellant cites to an example, I think, offer of judgments or offer of settlements. Well, by statute, those are excluded. But in this situation, there's no statute, there's no citation saying that this is by law excluded. What the Estate of Bush case stands for is this evidence is relevant to allow the jury to evaluate whether somebody has essentially driven under the influence, acted in that way.
Right, but I don't have any idea how much THC a person's blood would need to have for them to be intoxicated. And that, as a lay person, isn't that something that we require experts to evaluate for the jury? Isn't that something that would be required for the jury to make that leap?
I would, in the Michigan case, it is more likely yes, but in the state of Kansas, no. The state of Kansas, unlike the state of Michigan, is a conduct-based DUI statute. The state of Michigan is a numeric-based DUI statute whenever it comes to THC. And so what we have to prove in that instance is that somebody was incapable of safely operating a motor vehicle, which means you can take bits and pieces of circumstantial evidence, weigh them, and come up with a decision. And here we have somebody who's on a motorcycle for at least about 3/4 to a mile away from where the wreck happened, is driving and weaving through cars, going 15 to 20 above the speed limit, comes up near the intersection and guns it. Well, there are very few reasons why somebody would be willing to do that. One, they have a death wish. Two, they're intoxicated or impaired. Or three, they just didn't want to make a smart decision. And so allowing us to have that evidence allows the jury to evaluate whether somebody is incapable of safely operating a motor vehicle. And one thing that I would point out is in the contentions, that was never denied. It was admitted by the appellant on the trial level. The only thing that they denied was the nature and extent of damages, and then they claimed comparative fault. If it was an issue, or if they didn't think it was the truth, surely they would have simply put down that they deny it.
So you alluded to at the beginning, I think, of your argument, to the topic of, so if we were to find that the objection was preserved, that the evidence wrongly was admitted, can you talk about why you think that any error would be harmless?
Yes, if the court finds that the procedural hurdles of contemporaneous objections are overcome, and also the fact that the court did abuse their discretion, it's harmless because look at the verdict. An example is the McCollin case. It's Kansas Court of Appeals case from 1993. In that case, the jury awarded 30.4% of the requested relief. I think it was almost 1.8 million, and what the jury gave was 541,000. Here we have a case that the jury gave us the jury gave us 640,000. We asked for 1.6 million, and they also gave Ms. Paxon 5% fault. And so there is no inflammation of the jury in this case by this evidence. It wasn't argued, contrary to what appellants say, wasn't argued in closing. We stuck to exactly the conduct of the defendant and the unequivocal and uncontested damages of Ms. Paxon. So this matter should be affirmed, and there's no need for a retrial on the issue. Thank you.
Thank you, counsel. Mr. Cooper, you have 3 minutes rebuttal.
Yeah, I confess, I too don't know how much THC is needed either, and I don't think most lay people do. And that's what these courts are saying. That's why they need expert testimony. Anecdotally, I hear things like people are relaxed and perhaps a little slothy and perhaps hungry, but I don't know that it makes you speed on a motorcycle. I've never seen anything that would suggest that. But that's all lay, and we're not, I'm not an expert. As for your question about harmless error, I think, first of all, you see in State versus Benoit, State versus Pennington, State versus Scherer, that, you know, you have cases where the Kansas courts are saying that there is a taint, there is a stain that comes with, you know, an association with drug use, or that someone is stoned at the time of the accident. I think of it this way. If there's a car accident and someone gets in an accident with somebody who merges into their lane, and then the officer says, oh yeah, and the person was high on marijuana or was drunk, you know, and that person is to relay what happened to his friends. He doesn't say, oh, I was in an accident, somebody merged into my lane. No, they're gonna say, I got hit by a drunk driver. I got hit by somebody who was stoned. You know, this is something that is impactful, even if it's said very succinctly, you know, it's gonna stick with you. And I think it's gonna be the headline, not, you know, I got merged into by another car. So I think it is a big deal. I think Kansas courts in Benoit, Pennington, Scherer, and Brockenshire, where the appellate court overruled the trial court because the trial court erred by introducing evidence of drug use, which the court found to be prejudicial. So I think, you know, Kansas courts are saying it is a big deal.
Counsel, how do you respond to opposing counsel's suggestion that you weren't arguing fault, you were arguing amounts of damages, and how does that affect the harmlessness? I mean, if we're not talking about whether or not Mr. Lane was at fault for this accident, then how is the admission of THC then harmful?
Yeah, the appellee was actually awarded 5% fault. They were looking at fault. As for, you know, he said that there was only a small percentage of the trial that was devoted to this issue, and you need to look at everything in context. That is exactly our point. That the court, when it ruled pre-trial, it had everything in context that came in on this one issue. It was succinct, it was impactful, and it was all before the court and put in a can before trial.
So how would you respond to counsel's assertion that you're mischaracterizing the continuous objection?
The continuing objection, as you can see on the record, is that it was offered by the opposing counsel, and he said that because there had already been 2 or 3 objections, and the opposing counsel said, I'll give you a continuing objection. And what you can see on the record when you look at page 42 is that he says, I agreed to a continuing objection. And it was made during, and as they're discussing, and as you'll see in the transcript, this was made during the trial deposition testimony, what was actually played before the jury. And that context matters.
Thank you, counsel.
Thank you.
Thank you both for your arguments. We will take this matter under advisement and issue an opinion as quickly as possible.